I will turn it over to you, Jonathan.
Thank you so much, Steve. And thank you everyone for joining us again today. The last time we got together, I gave a presentation on supported decision-making that I hope was interesting and informative, but I also hope it raised a lot of questions in your mind. At no point have I, as I said that day, am I saying there's only one way to do things? Am I saying there should never be guardianship? Am I saying that you should always work with people with disabilities in a particular way at a particular time? In fact, supported decision-making by its very nature is individualized to the person and the person's needs. So what I would really like to do today is spend time answering questions or asking you questions about your particular experiences. If you are a parent, has there come a time where you have had to make that difficult decision? Are you thinking about making that difficult decision about seeking guardianship for your child? Or have there been times where you thought in your child's special education or supports and services, it might be beneficial to learn about these things and would like to know how you could ask for it? To professionals, have there been times where you've had to talk with a parent about guardianship? Have there been times when a parent has told you they want guardianship and you've had some doubts? Are you having questions about ways to incorporate supported decision-making into what you do and what can come next? So with that in mind, I really would love for this to be interactive. So if anyone has any questions or comments or wants to know some more information, please just take yourself off mic and speak up or put it in the chat box. I know it's always hard to be the first one. You're thinking this is Zoom, it's not comfortable, but it's a chance for us to talk together. By the way, I have a list of questions that were submitted before. I can always go through with that, but I think it's better if you've got some individual situations, but we could start off with those. I see Ms. White had a thumbs up. Did you have a question offline? Please feel free to reach out. Just remember, if you're giving advice about your family member, it's an individual exploration. It's not the kind of thing that's going to happen like that. Although if we focus on supported decision-making as a natural thing, something we do every day, I think we can treat it as a natural extension of what we already know. Remember, the goal is not guardianship or not. The goal is self-determination, whether you're in guardianship or not. The goal is for each person to have as much control over their lives as they possibly can, because 50 years of studies say that's a very good thing. But I'm never going to say, just using your family member as an example, that he or she should never go into guardianship. That's not my place. As I often say, my godson is in guardianship, and thank God, because my sister empowers him through the guardianship. He has a lot of self-determination. So make that the goal and make supported decision-making the vehicle. Anyone else I can talk to?
Jonathan, I'm Greg Matthews with
Hi, sir.
SST 11 also. I play on both sides of the fence. I do professional work at SST 11, and I've also been a legal guardian for my adult brother for, oh God, over 20 years now. And I think sometimes that when people start exploring guardianship, they don't know what all the implications are and what it involves. In Ohio, in the past few years, the state legislature passed a couple of laws that increased professional training for guardians and actually developed more oversight. So if somebody's considering going down the guardianship path, they really need to explore what all the responsibilities are with that.
Well, totally. And again, thank you for the comment. The first thing I'm going to say is there shouldn't be offense. There shouldn't be providing information and being a guardian fence, because it all comes down to the same thing: empowering the person that you work with that's in your family to the maximum extent possible. And again, there's nothing wrong with being a guardian. I use my godson, but also a real professional mentor of mine. One of the people who's the earliest published legal scholars on this issue, named Robert Dinnerstein, Bob testified in the Jenny Hatch trial. He's the guardian of his sister. And again, it's not because he is seeking to hurt, he's seeking to help. And he talked about how he empowers his sister, for example, for healthcare. I'm sure this is something that we've all done, whether we are guardians or not. But his sister, who has intellectual disabilities, had to get an electrocardiogram, an ECG. And the doctor was asking her questions to make sure that she understood what that meant and could consent to it. But he kept using phrases like, when you get the ECG, when we do this test. And Bob just said, do you remember last year when you had the test where they put the electrodes on your chest and they measured how well your heart beats? She said, yeah, I do. Because the doctor would like to do that again. Are you okay with it? And like that, because Bob provided that support, she was able to give informed consent. So guardians play a huge role in this. Now, to your second part of your question about what you're getting into, the legal ramifications of being a guardian. Yeah, it's great that Ohio in several counties have training requirements. I gave training in one of the counties on supported decision-making. I absolutely support that. The main legal ramification of guardianship is unless the court specifically reserves rights in Ohio, the person loses all their rights. It is assumed to be a plenary guardianship. My sister, my example, had to fight to reserve many of James's rights. She was just told, no, this is what we do. She said, no, I don't want that for him. So in Ohio, unless you're fighting, the judge will just check off all the boxes. So that's number one. That's the main legal ramification. But the second one I would say around the training, I think that's hugely important, not because we don't trust people to want the best for the people in their life, but because people may not know the ins and outs of the system, right? I mean, not to be flip, but you need a license to catch a fish. You need a license to drive a car. Shouldn't you get some training before you drive someone's life so that you know what options are out there, what services and supports are out there? Because that lets you do your best possible job. The public guardian in Ohio, APSI, years ago, I did a training for them because their whole point was we want to make sure our guardians aren't just people who say yes or no, but people who build the person's abilities and the person's life. So your point is spot on. And I think it's absolutely a good thing. I think everyone, when they're having that conversation, when they're thinking about becoming guardianship, should do a little research into what that entails and what it means. I use the example all the time on meaning well, and the vast majority of guardians mean well, 98%. Yeah, there are some awful people out there, but the vast majority mean very well. The problem is when you mean very well, but you don't know the potential consequences of what you're doing, bad things can happen. And that would be the opposite of what you want for your loved one. So, Mr. Matthews, thank you. You're spot on. And I think that's a very good thing. And Ohio is hopefully leading the way on that. Others? Who else can I talk to?
I'll go next. So I am a parent mentor for Centerville and Oakwood schools. So I have this conversation with families frequently. Like you said, I just give information. I'm not, persuading one way or the other. And everybody's situation is individual and different. But I was having a debate. I also am a parent of an 18-year-old boy with Down syndrome. And a lot of my friends have children of that age who have children with Down syndrome. And I was having a friendly debate with a friend. And for my son, I have chosen supported decision-making, and she has chosen guardianship. And the reason she said was to protect her from a predator who wants to marry her daughter and take her across state lines. And really that doesn't make sense to me, but I didn't have a good comeback to that argument. What could I have said?
Well, first of all, whether it's an argument or not is still up in the air. Obviously, you're both moms who love your children very much, and we don't know the specific situation. Okay. We don't know whether this is an example. There was a case in New York, a very famous one called the DD case, where the son, who I think had Down also, wanted to get married. And the mom did not want him to. It wasn't accusations of being a predator. It was just, she said she wasn't the right person for him to marry. And it wasn't a good decision for him to make. And she would make a better decision if she was the guardian by forbidding him to marry. What the court said was that the question isn't whether mom could make a better decision than son. The question was whether son was able to make decisions with support, because we're all going to make some bad choices. You've all heard me say, raise your hands if you've had a bad relationship. Those bad relationships teach us what good ones are. So starting there. But on the other hand, this may actually be a predator. It's not for me to say that judgment. However, here's some things I might have considered in that one. One, if he's truly a predator, Adult Protective Services is right there, as are orders of protection. And I would suggest it's going to be a lot better and safer if this guy is dangerous to have an order of protection against him, meaning he can't be around your daughter, than guardianship, which says he can't marry your daughter. Because ultimately, who really thinks that being someone's guardian is going to keep that person from doing something they really, really want to do? It's one of those arguments that falls apart when you think about it for 10 minutes. I have to get guardianship to make sure my child takes his or her medication. Guardianship isn't a needle. It doesn't make you gain 50 pounds of muscle that will help you force your child to take meds they don't want to take. Guardianship is not a suit of armor or a chastity belt. So if what we're doing is seeking guardianship to prevent a marriage, if the daughter really wants to be with that man, she's going to sneak out and she's going to be with him, whether they legally can get married or not. An order of protection in that situation might criminalize his action. A guardianship prevents a marriage, doesn't prevent, an elopement. So that's one thing. I call that the Rapunzel theory, because no matter what we do, we think we can put Rapunzel up in the tower. We think we can keep Rapunzel away from society. She got out. Do I see young people on screen? That's Tangled from Disney. I always have to qualify my comments depending upon my audience. But if we assume Rapunzel's going to get out, then our better move is to educate Rapunzel. I used the example in my last presentation about the studies showing that self-determination is correlated with safety. There was a series of studies done that found that women with intellectual disabilities, who are more likely to be abused than any other, who were more self-determined, were better able to recognize and avoid abusive situations. So to keep a child safe, and that's every parent's first obligation, I'd never question it, right? To keep a child safe, we have to not think sheltering is the way to do it. It's actually building abilities. Now, there's no good answer ultimately to your question, right? What do I do to protect my child from someone I think is a predator? But I think if this person truly is a predator, the better move is Adult Protective Services. If it's just the wrong guy, that's a whole other question. And I think we're really getting into a can of worms there that I think is better to provide advice and information and hope the right choice is made. Because if she really wants to be with him, she's gonna. So I'm sorry for that very long sermon, but thank you for the question, Ms. Milhouse.
Thank you.
Are there other things we can talk about?
I got a question, Jonathan. So as a SST consultant, part of what we do is we answer calls from districts, from parents, from students sometimes. And one question that I have received is a 18-year-old student parent was pushing for guardianship in an IEP meeting, but the 18-year-old student did not agree necessarily with that. What are some like best practice strategies, discussion points that you would recommend for educators when having what could be a tough conversation with opposing views on different sides of the table about guardianship?
It's a super tough conversation. And the first thing I want to do is throw this out to the group. Has anyone ever had to face this before? And what did you do? Or what did you think you would do as a professional? Anyone? Well, I can tell you what my advice is. And like I said, it's super tough conversation. My real overarching advice is that guardianship, yes or no, really doesn't have much of a place in the IEP conversation. Think about it this way. I'm going to share a screen. And I know that's a somewhat controversial statement, but let me show you what I mean. Ultimately, what we're supposed to be doing in the educational context, because whether a person's under guardianship or not doesn't change two things. It does not change the obligations under IDEA. Whether a student is under guardianship or not, special education law says that a school's responsibility is to prepare students for further education, employment, and independent living. As we know from other studies, we know that students who are more self-determined are more likely to be educated, employed, and live independently. But here's my overarching question and point. Whether or not a student is in guardianship, you can still, and in fact, you must still do the things on your screen. And as we have just discussed, you can encourage these things, whether a student's in guardianship or not. As I told Mr. Matthews, it's not a fence we need to be on either side of. It's one issue. How do we ensure self-determination? How do we ensure what over 25 years of studies in the school context has found that self-determination is the ultimate goal of education? And if we start there, if we assume there, then guardianship, while it may be a bad choice for a parent, and it may be something you can discuss with a parent, and I would hope if you saw a child who you think didn't need it, you would discuss alternatives with the parent. But whether or not the parent makes that choice, it doesn't lessen either your ultimate goal of helping that child be as independent as possible, or your legal obligation of doing it. So when I get that, well, what do I do? Mom says she wants guardianship and the kid, I don't think the kid needs it. I think it's a great time in the IEP context to have a great discussion about things like we've discussed, about studies showing that self-determination is the key to a better life, about showing that guardianship, when it's unnecessary or undue, can lead to a worse life. Certainly, you can have that discussion, but regardless of what the parent decides, there's still things that you can and should be doing. You can still, for example, be working on things like supported decision-making in IEPs, whether or not the student's in special education. We can have I statement goals that exercise self-determination and incorporate supported decision-making, even if the student is in guardianship. We can educate the parent and the student, like DC Public Schools is, on how to implement supported decision-making in the educational and life context, and then keep having that conversation with the parent, who might then change his or her mind or move to remove any guardianship they have. Is that likely to happen after 18? Probably not, because it's probably a parent who's been told they have no choice. But let me tell you, if you start from a young age, and again, up on your screen is DC Public Schools policy, they're starting to incorporate SDM with 3-year-olds, which is just choice making. Then what you can talk to that parent about is, remember all those things we've done for all these years. We've seen your student make decisions. We've seen the support you've provided that went well. So we think as part of transition planning, and remember, transition planning talks about acquisition of daily living skills. And what's a more important daily living skill than decision making? What is a more important post-school adult living objective than being independent? You can incorporate that as part of a transition goal for a child post-18. And all that time, you're not arguing with the parent that he or she made a wrong decision. Because I don't think that's your place. But you are talking to the parent about goals and objectives and independence. And if the parent keeps engaged in the conversation, maybe you can help sway it. But I think, again, the risk of repeating, your goal is self-determination, whether that's in guardianship or not. And I wouldn't get yourself wrapped up in making the guardianship or decision choice with or for the parent. In fact, I honestly never recommend a school recommend guardianship. I just don't think it's your place. I don't think it's right. It's just, there's nothing in the IDEA. Yes, I know transfer of rights says child 17, when the child is 18, child is an adult and gets decision-making authority. And as I always say, nobody told my mom that. I just became a legal adult at 18. But there is nothing in the law that says schools have to say as part of that, unless you get guardianship, you can't be involved in an IEP. Because that's simply not true. Nothing says that unless you're guardian, you can't come to an IEP meeting. Every IEP meeting notice says you can bring who you want. And if we're doing what best practices talks about, like DC public schools, and we're talking about supported decision-making from a young age, DC public schools, as we know, give students the option to do a supported decision-making agreement at 18 and says, going forward, I want mom there, I want dad there, I want them to have access to stuff because they're part of my team. It's something we build from the beginning. Self-determination, supported decision-making, teamwork is built from a young age. It's perfectly consistent with what you're supposed to be doing with IEPs anyway. I mean, the IEP meeting process is a really good definition of supported decision-making, isn't it? The teams around the room, they work with the student and the parent or an advocate to discuss goals, develop the best possible goals. That sounds an awful lot like an awfully good dry run for a supported decision-making team. So my advice, again, Steve, simply put, is it's not an argument you have to get into. It is a skill educational professionals can teach from a young age. The last thing I'm going to say, and I'm going to caution you to talk to your school board attorney before you do this. If you really think someone is going to be put in guardianship who doesn't need it, or is in guardianship who doesn't need it, you can write to the court. The court is supposed to review every year what's going on anyway. And you can simply write a letter that said, I'm X's teacher, I'm X's counselor, etc. We work with X on these things, and I don't think he needs a guardian. And that might at least make you feel like you've done everything you possibly can. Again, your school board attorney might not be a huge fan of that, so take that with a grain of salt. But there are things you can do. I think the things that you should do are the emphasizing supported decision-making, self-determination, whether or not the person's in a guardianship. Again, sorry for the very long-winded answer to a short question, but I think that would be a really good best practice. Anyone else?
Hi,
Oh, go ahead, Ms. Lambert.
hi. I'm actually with Cuyahoga County Board of Developmental Disabilities. And we've been able to kind of set up a system where when teams are saying somebody has to have a guardian, that we kind of vet that whole process and make sure that they're looking at alternatives and things like that. And when there have been concerns about a guardian or whether one was needed, we've worked through our general counsel and approached probate court and asked for it to be reviewed or help the person write to the court and ask them to take a look at their guardianship. So
Okay, so before I even comment on that, I have to say how much I absolutely love the Ohio Board of DD system. Love it, love it, love it, because every county has a board of DD, and that is not something that is in many other states. Virginia, for example, has one DD council for the state. What I love about Ohio's Board of DD system is it can do local things in response to local needs. I've worked with several boards of DD in Ohio. I've got educational program going on with Perry right now. I did one with Pickaway. I have trained Richland. So I just think it's in every place I've worked with a board of DD, they've all had the same values, but they've had to go about it a little bit differently because their population's a little bit different. So that's what I love. And what the example you just gave is perfect. The Board of Developmental Disabilities, and if there are any parents out there or teachers who don't know about it, I strongly recommend you contact your local one, is able to provide supports and services to people with intellectual and developmental disabilities that are individualized to their needs. Sometimes through a Medicaid waiver, sometimes through state-supported systems. The key to me is the individualized part. And Ms. Lambert just gave a perfect example of that. If they're working with someone who is facing guardianship and they do not believe this individual requires it, they can take steps, I'm sure with the person's consent, to provide some advocacy and some information. And doing it through the county attorney is awesome. I have not heard of others that have taken that step. So I think it's a great opportunity. And I'm sure when you do it, you're not calling the parent names, you're not challenging, you're not saying it's poor motivation. You're giving information on what this person individually can do based on your experiences and how or why that doesn't meet the standard for guardianship. So absolutely kudos, Ms. Lambert. Thank you for sharing that. Sure. And again, I'd recommend people reach out to the Board of DD if they have questions. What else can we talk about?
So one question that did come in that did get submitted was, and I'm going to try to synthesize it. There's a few points made. I don't see the person on quite yet that asked the question, but they might be looking for their recording, I guess. The question is basically around like when an individual falls into guardianship, what like ramifications does it have as far as like are they still able to receive government assistance, healthcare, those kinds of things, as well as does it impact how much money they can make on a job or put away in a stable account? There's kind of a loaded question.
No,
I guess
lots to unpack there.
Yeah, in short, does it impact some of the benefits that they may be eligible for otherwise? Does it make more available? And I don't know if you even know specifically to Ohio, or if you can just talk generally what.
The answer is not to my knowledge. I do not believe in Ohio, and certainly not in other states I've worked in, that any supports or services are contingent on being in guardianship. And that has often been an incorrect assumption in many places, where just bad advice was given, or someone told someone they have to have guardianship if they want to get a Medicaid waiver, for example. Or if, in fact, again, the case that started this all for me, Jenny Hatch, the initial argument given to the judge before I got involved in the case was she had to have a guardian to have a Medicaid waiver. And that's actually or she had to be a guardian and be in a group home, pardon me, to keep her waiver. Both of which are somewhat antithetical to the idea of waivers, since waivers are there to encourage and empower independent living and community-based living. It was just that was what I call institutional knowledge. Nobody really had corrected them. But the idea that she had to be in a group home, for example, to get her waiver was categorically incorrect. And the idea that she had to have a guardian to have a waiver was incorrect, because having a guardian didn't matter. You can have a waiver whether or not you have a guardian. The questions you ask about money, I have never heard, ever, of a state law that gives you more money for being in a guardianship. I think, again, that's antithetical to things like stable accounts. For those of you who don't know, when you're on public benefits, SSI, SSDI, Medicare, Medicaid, food stamps, you are limited in the amount of money you can have. Generally, it's about $2,000. You can only have $2,000 in money and assets to your name. If you have more than that, you can lose your benefits. And in fact, I've met people who've gotten bills from the federal government. We've overpaid you for the last 10 years. You owe us $100,000. Not an exaggeration. I've literally seen letters like that. So obviously, we have to be very careful with how much money we have when we're receiving public benefits. The federal government created a program called the ABLE Act, ABLE, Achieving a Better Life Experience, that empowers states to create special accounts for people who are receiving benefits that will empower them to actually have some money. So in Ohio, that's called the stable account. And I can tell you the stable account is thought of as one of the best in the country. What an ABLE account, Ohio's stable account, does is it allows people who receive benefits or who would receive benefits if they applied to open up this special account, the stable account. And in the stable account, I have slides on this. I think this is going to be much easier. I'm sorry. Let me just share a screen on it. In a stable account, you can put up to $15,000 a year into the account. Here we are. So in a stable account, if you've heard of a 529 for education, where you put money away for your child and it grows tax-free, you take it out for education, you use it. The ABLE account, stable in Ohio, is like a 529 for life. The person or anyone on the person's behalf can put up to $15,000 a year into that account. And that account grows tax-free. And it has no impact on benefits. So instead of the rule of you can only have 2,000, if you have a stable account, and this is a great thing to discuss as part of transition, by the way, when you talk about independent living, is when you're talking about work, because many people don't want to work if they're on benefits for fear of losing them, is a stable account. It grows tax-free, that $15K a year. And as long as you have less than $102,000 in there, meaning if you have $101,999.99, it has no impact on a person's benefits. When they get to $102,000, SSI is suspended, but Medicaid continues. So what a great opportunity for people to have money, okay? Because a stable account can literally be used for anything. So many tiny words on your screen right now. The reason they're tiny is it lists all of the things ABLE accounts can be used for. They can be used for anything: education expenses, housing expenses, work expenses, life expenses, vacation, recreation. The idea is to empower people to have a good life. And I always use the example of it as being a pathway out of what one scholar calls a life sentence of poverty. Because if you're limited to $2,000 to your name, there ain't much you can do to have much of a life. Now, you need your benefits. They're keeping you healthy. They're keeping you in the community. You have to have them. But if it's a choice between having that and having money to pay for rent, it's a really tough choice to make. So the pathway example is one that I was inspired by a young woman in Indiana who was afraid to work. She was on benefits. She had Down syndrome. She's afraid to work. And she got a job at a hospital making minimum wage, part-time. Opened up an ABLE account, put money in it, and then took some out to get some additional job training that was offered through the hospital. And it paid for transportation and such. And through that, she got a better job, making more money, which allowed her to put more money in her ABLE account, which allowed her to take some out to get additional training, additional opportunities, which allowed her to get a better job. This young woman, the last time I talked to her, had worked her way through this system into a full-time job with benefits. She no longer needed SSI, SSDI. Is that going to happen for everyone? No. Is it a great example to talk about as that pathway to a better life? Absolutely. So I'm a huge fan of ABLE accounts. I know I've diverted, and Steve, I'm going to come back to the question, but I think it's really important for people to be familiar with this issue. In Ohio, you can go to stableaccount.com to learn about Ohio's. There's another website called the National Resource Center on ABLE, ablenrc.org, that can give you an overview of ABLE. So they're a great thing to either have if you're a parent or to talk about if you're an educational professional. Now, getting back to the initial question, I know of nothing that benefits guardianship to say that you can put more in an ABLE account. And again, it's antithetical to the idea, because the whole point of ABLE is to maximize independence, is to maximize people's opportunity. And in fact, supported decision-making is a perfect thing to use in tandem with an ABLE, because the big thing on an ABLE account is that the person who has the account is responsible for managing it. Y'all might have heard of a special needs trust. They work a lot the same, many of the same ways as an ABLE account. They also grow tax-free. They also don't count against benefits. But in a special needs trust, you have a trustee who manages it. If you want to take money out, you have to ask the trustee. The difference between an ABLE account and a special needs trust is an ABLE, the person who has the account manages it, has to make the decisions about how much to put in, how much to take out, what to take it out for. And as with guardianship, I don't tell you which you should do. My godson who's under guardianship has a special needs trust. In fact, his main reason for being under guardianship is he just can't figure out money. My niece, who has an autism spectrum disorder, has an ABLE account because she's working. So they're both are very good things. But if the person is managing the account, what a great opportunity for supported decision-making. ABLE accounts allow you to give access to the account to another person and say what that person can do, whether it's someone who just can see the money going into and out to help me do a budget, whether it's someone who has the power to deposit, or the person who has the power to deposit and withdraw. I get to make that call. But what a great opportunity to use supported decision-making to talk about balancing budgets, to talk about managing money. Because the whole goal is someday that person is going to have to be responsible to some extent for his or her life. So many things that we have end. School ends, right? But if we can empower people to have options for what happens after, what a great thing. And again, going back to that transition regulation, we are helping prepare people for the rest of their lives. So the answer to your question, very long answer, Steve, is no, I don't know of anything that advantages guardianship in areas like that. Okay. But what I can say is that there are opportunities, whether you're in guardianship or not, to empower. Question in the chat box, can a stable account be joint? I recommend stableaccount.com and ask that question. My experience is it's in the person's name, but the person gives access to a supporter. And at the highest level of access, it's basically the same thing as a joint account because a person can put in and take out money.
Yeah, that's how ours works. My husband and my son are on the account as a joint.
Okay.
And they have the same level of access as my husband and I have access to our checking account.
Perfect. I mean, it's a great opportunity also to talk to your son about balancing budgets. And, you know, I do a whole talk on finances that, you know, wants and needs. How much do I have now? How much do I have to earn?
We actually worked that in as part of his transition.
Awesome.
Goals this year. He's working at the school and he's using that money and budgeting it.
Perfect. That's if you think about it, those kinds of lessons can be part of special education too. I talk about boring goals, and I don't mean that as an insult to any educational professional. You guys have obligations you have to do in goals and objectives. Your goals have to be specific to the course. They have to be measurable. But if we think about making those goals more individually centered so that they are more interesting to the person. I mean, for example, Jonathan shall improve his mastery of addition and subtraction by memorizing tables and getting them right with 80% accuracy. That's a goal. It's specific, it's measurable. But is it meaningful? If I were to say, as an I statement goal, and we've talked about I statements, I can show you the slide on it. I will work with my teacher to develop a monthly budget where I have to deposit and withdraw money to meet certain obligations each month with different amounts of money each month. Well, look what that is. That's addition and subtraction. And I shall balance my budget 80% of the time. You just did an addition and subtraction goal that is measurable, that incorporates supported decision-making and self-determination. Whatever using the words. So when I was doing this out in, what county? I think it might've been Richlands. They put it in like their journal where they incorporated things like that into their IEP. And one of them said teachers had tears in their eyes because students who'd never been engaged before were now engaged. One student wanted to be a fashion designer. And when they learned that, they adapted all of her goals around that. For example, her English composition goals were around writing advertisements for her fashion design business. Same goals, same requirements, now meaningful. Math goals around things like paying taxes, etc. So there's a great comment there about life lessons. Yes, I think that's a great life lesson, while at the same time meeting one of the school's many obligations that I think, can be really tough. I mean, it can be tough on educational professionals knowing all the things they have to do and marrying that with all of the things they want to do. Teachers and education professionals did not get in this field to say no to students. Okay, there are parents out there. They ain't there to say no to your kids. They ain't there to turn down requests for services. They got into this field to do things to help and empower students. What you can do to work together is marry those two things. There have to be goals around math, but those goals around math can be very individualized to the person and matter to the person and incorporate what Stephanie called life lessons. And I think that's absolutely true. So I encourage that. And we can talk more about that certainly in the spring, or we can talk more about it now if you'd like. What else can we talk about?
What are ways?
I was just going to, oh, go ahead, Erin, sorry.
I was just going to ask, what are ways that you would recommend as school employees for us to kind of get the word out or explain more to parents about supported living? I think everyone knows the big term guardianship, but I think supported decision-making is one in which there's not really a lot of resources out there for sharing with parents. I noticed on your website, there's a few downloadables or resources on there, but are there any like key takeaways or things that you would definitely recommend that staff use to kind of get the word out?
The first thing I'm going to recommend is not to make supported decision-making an either or, especially not to first bring it up in transition when it's approaching 18. Simply put, if parents who are incredibly busy, it is hard being a parent. I got two 12-year-olds. They're trying to run me into the ground. I am going to outlast them, I think. But being a parent of a child with disabilities is so much harder because you have to be so many other things. Parent of a child with disabilities has to be the educational advocate, the legal advocate, the medical advocate, et cetera, et cetera, et cetera. So if at 17 and a half, schools begins having this conversation and says, there's this guardianship that you've undoubtedly heard about and that people have been saying for 1,000 years is the right thing to do. And there's this other thing with a long clinical sounding phrase, supported decision-making, that you've never heard about, but you should do. You know what's going to happen. Okay, what's going to happen is the parent is going to do what they know, what they feel safe with, what they've always heard about. So in educational realm, I recommend starting early. It's a values thing, isn't it? So what we've done, is this the right one? Yes, it is. So sharing, again, the DC Public Schools talks about it from age 3. And it's not talking about supported decision-making as a thing or a theory or a practice. It's about making decisions, right? Telling kids as young as 3 that there are decisions you have to make. You should get together with people and discuss them. Telling parents that it's okay for your kid to make decisions. We want you to be very supportive of it, encouraging parents to have kids at the IEP meeting as early as possible and talking about what the process is. Okay, I can put in the chat box before we go. I'll get a link to that policy. You can see what they've done, or I can forward it to Steve after we're done. That's probably a better option. There are also good materials available out there. Stephanie pointed out that Opportunities for Ohioans with Disabilities has stuff on supported decision making. I'm going to give you another example from hang on a second, from the Missouri Developmental Disabilities Council. They've got a series of publications on guardianship. I know because I wrote these for them, that I think are pretty good. So what I'm going to do is going to show you what we're talking about, and I'll share screen in a moment. Let me see where it is. Oh, good Lord. I used to know where this was. Perfect. Okay, so hang on a second. I'm going to share screen and show you what they have, and I'll put a link into the chat box for this. So we did a series of documents that these are designed to be easy to follow, and that have, none of these have more than 5 pages of text, but they talk about options. They talk about supported decision making. They talk about, the importance of decision making in a way that I think is designed to speak directly to people, saying you're often told you have no choice, that guardianship is your only option. Sometimes it is, sometimes it isn't. So it goes through, again, the issue of self-determination. Okay, the issue of that's the important part, whether you're in guardianship or not. And it gives some steps of things you can try around supported decision making. So putting it into practice, there are some areas to try. So there's several suggestions that are worth looking at with resources attached to it. The DD Council also, stopping share. The council also put out specific supported decision-making guides for specific situations, including supported decision-making in education, supported decision-making in transition planning. So I'm going to pop that into the chat box as soon as I re-find it. I'm not sure why it went away. Great. Here is the link to their supported decision-making resource page, and it will link you to these PDFs. So it's going to the chat box now. Like I said, with nothing being a be-all and end-all, I think these are worth looking at. They won't take you more than 5 or 10 minutes to read, and that was the point. So often, supported decision-making gets very, I'm going to say, clinicalized. It's like the example I always give is the procedural safeguard notice that parents have to sign off on beginning of the year. You have to put each and every possible thing, and it comes up with a booklet like that thick, right? And you know that no one reads it, right? Because it's that thick and it's got all the clinical language in it. Well, I've seen so much on supported decision-making that's like that. I've seen very well-meaning guides that are 100 pages long. And when you're a parent of a kid with disabilities, you don't have time to read 100 pages. So the goal with these and other entities, the Nebraska DD Council did one similarly. The goal is to break it down into manageable bites for specific parts of life. So I know that in the Missouri one, there's 2 booklets, one on supported decision-making in the IEP process and one in the transition process that I think could be really helpful to educate parents about why this is a good thing, and also to give schools some information on how to incorporate it. And it's the exact common sense things you would think it is. Do a student-led IEP. Talk about and make the goals I statements and meaningful to the student. Focus on decision-making as part of transition planning, because what's a more important adult living objective than being independent and making decisions? So there's no magic bullet is the answer to the question. You're not going to find one conversation you're going to have that is going to say, oh my God, light bulbs on. You know, as good as I think I am, I often tell people I need an hour for that initial presentation to help hopefully get people to go, that's interesting, I want to try this, because people have to come around to it themselves. Again, guardianship's been around forever. It's been around as the only option in people's minds for a very long time. And most parents want their kids to be as independent as possible. I have parents tell me when I meet with them, I want 3 things for my child: independent as possible, happy as possible, safe as possible. And that's a great mantra. That's what parents should do. So I say, okay, let's work with that. Let's work with ways to make that happen. So we're not telling them everything you know is wrong. That's a sure way to get them to move away from you. We're telling them that they're right, that their values are correct, that what they want for their child can be achieved in a lot of ways. Here's some ways to think about doing it. Like I said, the worst thing we can do is make it an either or question. If we do that, parents are going to pick guardianship every time because it's what they know. And there's nothing wrong with that. They want their kids safe. They should. The thing that we should be doing is showing them that their values are correct. And the way to get there is through empowerment. And that's just 50 years of science. So thank you, Ms. Curtis. Sorry for the long-winded answer. Hopefully, like I said, the link to those Missouri documents are in the chat box. It's really not self-aggrandizement, even though I did write them. I really like the way they break things down into simple bites. That was the whole point. Other questions? So let's look at some of the ones that I got before by the last one. So let me go into my Word. And I believe it's this one. Yep. So several questions were submitted before. Let's just go down them. How do you create a team for a young adult when many of the team members are older, meaning that they won't be around the lifetime of the person in need? And it's a legitimate concern, both for supported decision-making and guardianship, actually. When I talk to parents about guardianship, they don't think about their children outliving them. But in actuality, this most recent generation of people with disabilities is the first one that is statistically likely to outlive their parents. So the what comes next question is a big one. And with a supported decision-making team, I think we should be building that in, because one of the most important obligations of a person in a person's life, let alone a supported decision-making team member, is to help enhance that person's life, is to help that person have more experiences. So it's silly to think that the friends we have at 18 are going to be the friends we have at 80. If we're lucky, we might have 1 or 2. I'm still friends with a couple of friends from college. And I don't think I've talked to anyone I was friends with in high school outside of Facebook in decades. So we have to know that people are going to come into and out of our lives, whether we have disabilities or not. So that should be built in to the supported decision-making team framework. That's one of them, is how do we incorporate new members? How do we help the person seek out new activities where they might find new members? A big part of what we are trying to do is build people's life experiences. Okay, I often talk about, and I've done this in a few different Ohio counties, talking about a thing called dream boards, and a thing that's around envisioning what you want to do in your life. Not because supported decision-making is wish fulfillment, but to get an idea of what a person's values are. So I've done this in Richlands County for several years, working what they call their challengers class, where we work with them to do what we call a dream board. Nothing magic about that. Just go to Pinterest and look at vision boards. But the idea of the dream board is to encourage these kids. You know, here's some cardboard, here's some magazines, pencils, papers, glue, whatever. You got 45 minutes, you have an hour. I want you to represent on that paper what you want from your life, what your ideal life is, what your vision of fulfillment is. Okay. And the point from that is to learn what motivates that person. Again, it's not wish fulfillment. I get a lot of people who want to be Hollywood stars or athletes or singers. And here's the thing, I can't make you Beyonce if I'm part of your team, but I can find a place where you can sing. And I can find people who like to sing. And I can find community opportunities to be creative. And when we do that, whether or not the person becomes Beyonce, they're doing things that are important to them, that speak to them. And that's the way you meet people with common interests. That's the way we build our not just supported decision-making team, but our life experiences. Again, we make our friends because they have common interests as us. If we went around the room, we talked about what our dreams are, you got a bunch of different answers, and relatively few of us would have gotten exactly what we've always dreamed of. But if we're lucky, we're doing things that are consistent with our values. At 18, I wanted to play guitar for the Rolling Stones. I wanted to play left field for the Yankees. Not happening. I'm too small, I'm too slow, so saith the Milwaukee Brewers. And Keith Richards will never die. So these things are never going to happen. But what do they tell us about me? I am hyper-competitive. I like to be active. I like to be the center of attention. I like to be entertaining. Don't I have the perfect job for those values? I'm a trial lawyer, so there's all my hyper-competitiveness. I get to do things like this, where all of y'all, 21 people, paying attention to my face and what I have to say. What a perfect evocation of my dreams. So now imagine doing that in the context of a special education IEP, whereas we talked about making goals matter to the student, but two, with regard to a supported decision-making team, it's a way to help the person branch out. So much of what an SDM team does is figure out what the person wants, how they want it, when they want it, and from whom. Well, we can use that to always have that person be branching out and meeting and hopefully doing new things and meeting new people. And that's going to bring those new people into that person's life. Again, as we grow and experience new things, new people come in our lives. My supported decision-making team does not have the same people in it now as it did when I was 18. And good thing, by the way, you should have seen who I hung out with when I was 18. But as we get older, we do new things. We learn new things, and that's a good thing. So we shouldn't think that a team will be static, because life isn't static. So the team's job is to encourage the person. Last example on this. There are some people who are what the American Bar Association calls unbefriended, and particularly people who live in institutions. They don't have family members, they don't have friends, they've been in the institution so much of their lives. And my feeling is that doesn't mean the person has no one in their lives. Many people form very close relationships with professionals in their lives. Sometimes a person's direct support professional knows them best. Many times, I imagine some of you could say, as an educational professional, I've developed a bond with a student or a family. Okay, that means you're a supporter. But it also means, given the relatively transient nature of what you do, kids only be in school till a certain age, part of your job is to support the person to find new supporters. So teams evolve just like people do. So that's what I say. Make sure people have the best chance to evolve. Before I move down, anyone else have a question to build on that or anything else like that?
Just kind of a follow-up. So hypothetically speaking, if I'm the guardian of somebody and I pass away, what happens to that individual? Is that something that that people who are guardians should then consider writing into wills and estate planning and things like that from a legal perspective, or how, like,
You can't leave guardianship in a will. In fact, the ultimate guardian is the court. The court decides who the guardian is. The court doesn't like what you're doing as guardian. The court can remove you. In fact, the court is supposed to remove you when it does annual reviews if it finds you're not doing your job. So the court's the guardian. And I tell people that not as a threat, but as a caution. Because when you become a guardian, what you're really doing is inviting the court into your life for the rest of your life. So when you pass, the court will choose the next guardian. Now, if you indicate you want that guardian to be your son, your daughter, your brother, whoever, there's a good chance the courts can take that into consideration. If the person says, I want my guardian to be this, that, or the other, there's a good chance the court will consider that. Ultimately, though, the court decides who the guardian will be at any time. And again, given the longevity status of people with disabilities, how long they're living, there's a fair to middling chance that their guardian will eventually be a stranger. So that's something we always have to think about. And for me, another reason why it's important to build teams so that the person isn't alone at any point in their life and has the ability, the opportunity to build teams and friendships around them. Others?
Ask a question. Say a family has the guardian has terminal illness and they realize that.
I'm sorry, Ms. Thomas, would you please repeat that? Say the family has what?
Say the guardian has terminal illness.
Okay.
And they know that there is no cure. And is there a way for them to step out of guardianship and have someone else come in to guardianship? Like, I know it's all a court decision, but
Yes.
have someone step into that role before they're too sick to be able to care and for their person they have guardianship with. And if that's the case, what are some good steps or things to do? I know the team is there, but that's unfortunately not always the scenario. And as I work with families to try to help them think through that process. Any tips on that? In
this scenario, Ms. Thomas, the person is under guardianship, right?
And our guardian has terminal illness.
Okay. So here's what a best practice would be. Okay. And please remember, we're being recorded. I'm not an Ohio attorney, so I strongly recommend people consult an Ohio attorney, and please don't consider this to be legal advice. It's more of a best practice tip. Okay. A person at any time can ask the court to appoint a co-guardian. There are many people who have more than one guardians. In fact, if you think about it, again, because guardianship is not a suit of armor, you may not be there when a decision has to be made. I recommend this for not only guardianship, but powers of attorney, is that there should be layers built in. What happens if I'm sick that day and the person I'm guardian for needs a decision made? Okay. So what I would do, were I the guardian of my child and I was terminal, I would immediately ask the court, I want to be guardian as long as possible, but I would like to appoint this person to be co-guardian with me. So that person becomes, if the court approves, guardian just like me. When I pass, or if I can no longer do it, then there's a guardian in place. We don't have to have that vacuum. Okay. So to me, that's just better planning. I would recommend talking to an Ohio attorney about how to make that happen, but that's what I would do. I would seek to have a co-guardian appointed to help me. And I think it's the same, like I said, with a power of attorney. There was a case I did for a young man in Washington, D.C. named Ryan. And Ryan had been under guardianship for 15 years. He didn't want to be under guardianship. His mom, who was his guardian, didn't want to be his guardian. They were told they had no choice. Long story short, he worked with me. We got him out of the guardianship and we did a power of attorney. But what we did in the power of attorney was we said that Ryan was going to make decisions with support. There were some decisions that were reserved to the power of attorney, but we created a redundancy. If mom is available, there was 3 guardians, mom, dad, sister. And when possible, 3 agents, power of attorney, they were going to try to work together to come to a decision. If they couldn't, mom controlled. If mom wasn't available, then dad. If dad wasn't available, then sister. So we had levels built in for any situation. And I think that's just a good idea. And I think that's part of the idea. Notice how we built a team in there as well. They would try to work together. So the idea is, if you're concerned you're not going to be able to do what you need to do, you should get help as well. And that's what I would do. I'd seek for a co-guardian, knowing that there was something in place when I was no longer able to do it.
And another scenario is there are many families I work with. It is very common that the stress of having a child with a disability causes pressure on many marriages and relationships in their single parent homes. So encouraging a single parent to be thinking about these things when they're very healthy, and helping either with self-determination, moving that individual towards independence, or getting a co-guardian is a very thoughtful, something they need to really be thinking about and planning for, I would say.
1,000,000% agree.
I noticed in the chat that in some counties, that's not a thing, is to have more than one guardian. So that is something I'm glad someone brought up to consider. To have someone in place to take that role if necessary and have those conversations prior. I didn't realize that was the case.
I will tell you, I didn't see anything in Ohio law that prevents there from being a co-guardian. And I've looked at your law. If that is truly the case, my guess would be it's because they don't want conflicts. And the way to solve that is to name one the primary guardian. But be that as it may, I think that's an opportunity for education. If that's truly the situation, then the person who's terminal, what I would do would be to ask to have someone what's called substituted. Again, taking it out of the uncertainty for when I pass, to say to the court, and your law does allow a guardian to resign, but you can resign with a suggestion for someone else. Again, you're getting ahead of it. In your other scenario, ma'am, again, I agree. And we have to consider that stress level, no matter what we do. Speaking directly to the educational professionals, I mean, it is incredibly hard to be a parent of a child with disabilities. And that stress and frustration level, I know you've seen it come up, okay? I'm not telling you anything you don't already know. I think that's a time to recommend to the parents that they seek their own support. There are people in our lives. Again, all of us use supported decision-making. We don't call it that. But every time you call a friend for advice, you're using supported decision-making. So the key that I tell parents is that you're not alone. You can't be alone. There are people out there going through the same things that you are. And as toxic as social media can be, this is one of the times when it's really helpful, is making those connections with people who've gone through the same things you do. Okay. And no matter how awful the situation you're in feels or seems, there's a 99% chance that someone else has gone through it. And by talking to that person, maybe you'll find a way through yours. So I encourage Google as a friend, parents of people with X, support groups for Y. Until you have, when you see and hear and speak with people who've been in, are in, have come through the situations you find yourself, it does seem insurmountable. But when you talk to someone who's been there, it gives you a little bit of hope. So what you can do as a professional when you talk to them is maybe help them with the Googling or suggesting the Googling. I think it will make everyone's life better. because then you'll have a better informed parent. You'll have hopefully a less stressed parent, and it will allow you as professionals to work with that parent, hopefully more constructively. Other questions? So one of the ones that we had that was sent out was, what happens if you're a parent, you're the guardian, and you decide that your child doesn't need guardianship? It works. You've worked with the school has given you information, you've discovered supported decision-making. What can you do? Well, good news on that, because Ohio covers that. We have law that discusses it. So let me punch up that one. We know in Ohio that the job of the guardian, so Ohio law, is to make decisions in the person's best interests. That is the standard put on the person. So no matter what you do, even if you disagree, if it's not what you would do, but it's in the person's best interests, you should do it. So what do we know is in people's best interest? We know from 50 years of studies, et cetera, et cetera, et cetera, that self-determination is in people's best interests. We know that people who are more self-determined are more likely to be healthier, happier, more independent, employed, safer, et cetera. So what I say is, a person may need guardianship. There may be a person who at 18 is not ready to control his or her life. Which one of us was ready at 18 to control our lives? But what I talk to people about is guardianship doesn't have to be a lifelong situation. Sometimes people just need a little bit more time to learn things. And this is something educational professionals can be a part of. Guardianship can be a really good thing if a person has very specific limitations that are preventing him or her from living independently, making their own decisions. Then guardianship can be a great way to address those limitations. A person can go into guardianship at 18 with specific goals. There was a case I was involved in Vermont that did exactly that. The person went into guardianship at 18, and what the court said was, these are the things that need to be worked on, the guardian should be doing. 1, 2, 3, 4. And then they sunset the guardianship in 2 years, meaning unless there is evidence that the person still needs this, I'm going to end the guardianship. So it kind of gave the guardians marching orders, what to do to help the person to be self-determined. Ohio's law kind of recognizes that idea. Okay, again, remember, 1, make those decisions in the person's best interests. But 2, if at any point the guardian feels that this person has learned, has developed those skills, has figured out something, that guardianship can, and in fact, under your law, I think must, return to the court and say, either change the guardianship, meaning Jonathan's figured out his finances enough that I don't think he needs a guardian. We're going to keep it for the other stuff, but let's free him on finances. Or Jonathan's got this figured out. He doesn't need a guardian anymore. If you look at guardianship that way, is it going to be this way for everyone? No. It can certainly be this way for some folks. That guardianship becomes a way station. A way station toward self-determination, meaning a person at 18 might need it. And at 18, the person needs some skills to be built. Well, the guardian can address that. If the guardian's doing what the guardian's supposed to be doing, working on self-determination, working on best interests, helping them learn their skills, then wouldn't it be awesome for a guardian to go back to the court and go, good news, judge, I did my job, fire me. That is a way, and it's perfectly consistent with your law. If you as a parent or a guardian feel that your child needs a guardian, that's fine. Again, it's not my place to say no, but what it is my place to say is you do have obligations as a guardian. And when you feel your child has achieved, if you feel your child has achieved, then you do have the obligation to go back to the court and say, change this or end this. And that's something that you as educational professionals can talk to parents about, not in the context of you got to get rid of your guardianship, but in the context of talking about skills development or suggestions for skills acquisition. Remember that as part of transition planning, and I'm going to share again, as part of transition planning, one of the things that you're supposed to be doing is helping the student build those skills, is build those everyday living skills right here that include independent living, that include linking to adult services and community participation. So part of what you can be doing at 15 and 16 and 17 and 18 and 19, 20, 21 is helping as part of transition link the parent and the student to supports organizations, to the board of DD. How awesome would it be to have the board of DD at the transition planning meetings? In some counties, they are there. That's part of the whole point of my project in Perry County, is to have OOD and the board of DD be part of transition planning. How great would it be to have transition goals include things like decision-making and building a support team? We talked about I statements. Wouldn't a great transition goal be, I will identify 5 people to be part of my support team after I leave school? Or I will develop, I will report to the team my dream job. These make the student have to be directly involved. And they build the exact things transition planning is supposed to build. So it's not your job, as I said, to tell people to do or not to do guardianship, but it can be your job to help that person build the skills they need to avoid or emerge from guardianship. We have about 10 minutes left. Of course, I'm happy to stay as long as you have questions, but is there anyone else who wants to build on that or wants to talk about anything? Okay, well, going down the other questions we received after the last one.
Jonathan, there's a comment in the chat
great.
box.
Sure.
John says, it was my understanding that transition goals cannot be I or student will, like in terms of that. And that kind of goes to the compliance components that Ohio has set forth. They do kind of, it's tough because I think as educators and practitioners, we totally agree with your I first statements, but the compliance would say otherwise in Ohio. So it's kind of tough to find that balance. The transition goals, the requirement in Ohio is that it's written, the services are written as to what the adult behavior is as opposed to the student. So if the student, for instance, if the student is listed, if it says the student will, then that would be found to be non-compliant by the Department of Education, which I think kind of, without getting down the rabbit hole, opens up a different conversation for, you know, our advocacy to maybe change some of the language around some of those components. But
well, without saying what your Department of Education should or shouldn't do, and I certainly think there are good studies around the I statements and the use of involving the student directly. You got to do what the Board of Ed requires you to do, but how you get there isn't set in stone. You could work with the student to develop I statements and then translate that into Ohio Board of Education language. It's really, when we're talking about supported decision-making, like I said, it's a vehicle. So is planning. It's a vehicle. If at the end of the day, you have to put it in the formal document in certain language, how you got there is the important part. So I would encourage you to think broadly. Clearly, you don't want a non-compliant IEP, but the methodologies you use, the cooperation you make is yours, and it's designed to be the most effective that you can. Ultimately, what the document says, as long as it has the important components of what you discussed, is secondary to what you did. And I think most parents would agree with that. It's about the journey in this case, because that's the skill building. So yes, I avoided the rat hole. I think
Yeah.
there are, however, there are, what I would say is that we're all more than professionals. We're all advocates. Again, to every educational professional, you're in this field because you wanted to make a difference. And that's not a cliche. That's a mission statement. And there are many, many ways to make a difference. And what we do is, by definition, advocacy. We advocate for our children, we advocate for our students, we advocate for our coworkers. If you have an opportunity to comment on state policy, you can. If you work as a support team about the best ways to implement state policy that might incorporate the values and methods we talked about, while at the end of the day hewing to their required language, that's great too. It's all about the things you do together to empower the person. Remember, the goal is and must be self-determination. That's why you're there. That comes right out of the IDEA. And one more thing, I didn't mention this. There is a study that shows the following. When students have goals that are designed to build self-determination, they end up more self-determined. They do better in and out of school. That's exactly what you all got into this field for. You got into this field for them to be successful students and successful adults. We know from another study that students who lead their IEP teams are more successful adults, because you're empowering them to practice. You are empowering them to learn what Stephanie called life lessons, life skills. And that's why you got into this field. And that's the difference you can make as a part of this field. It's why when I hear people criticize schools and criticize teachers, I get a little antsy, because teachers are here to advocate. Educational professionals are here to advocate. It's giving us all the tools we need to advocate successfully, because that's the end goal. As I said, I've said to parents all the time, there's no education professional who got in this field to say no. I think what we should learn to say is how to build so that the ultimate answer is yes. Yes, meaning self-determination. Yes, meaning successful student. And yes, absolutely meaning successful adult. Other questions in the few minutes we have? I'll take one more from that questions we received earlier.
I think Stephanie came off mute. I don't know, Stephanie, did you have one?
I did. It might be a loaded one. I am a parent mentor, so I work directly with families, and I'm trying to choose my words. Sometimes I see a codependence, unhealthy codependence between parents and their children. A lot of it is a single parent who has maybe only one child, and because their lives are wrapped around each other. But then I also see that individual, that student, having the potential towards a great amount of independence. Is there anything that you could help us, some training for parent and child that would bring up that issue in a gentle way, so that they could actually both see the potential that many people can see for their child?
It's in the
Do you
framing.
understand what I'm trying to say?
I
'Cause
do.
It's a
and
very difficult subject to.
I know exactly. I know
talk
exactly
about.
what you're talking about. I know exactly, and I'll choose my words carefully. A parent of a child with disabilities often has because of the incredible toll it can take, has a lot of his or her worldview, psyche, makeup made up in their child. Being the advocate, being the supporter for the child is the primary motivator for the parent. It's how they see themselves as their role. And sometimes that can lead to the parent being overly protective. How's that as my word? And perhaps not seeing the child's potential because the parent sees his or her role forever as the parent and protector. I've had many parents say, I'm always going to be the parent to my child. I say, of course you are, you're the parent. So to me, it's in the framing, because if the parent sees him or herself as the forever protector, supporter, advocate for the parent, for the child, we have to frame that properly. Of course you are, and you have to be, and here's some ways we can make this happen. Again, it's a process and a lifelong education and a lifelong experience. And it's not just saying you got to let go or you could. You just say that, you're going to push them the other way. It's kind of, what can we add? What else is there? You know, and it's, to me, it's always providing information. And again, the link to the Missouri DD Council stuff is helpful when it talks about available resources. It's always talking to the parent about adding, not subtracting their role, but adding in things so that the parent then is still in the role of supporter, because they can be the prime mover in their minds of adding the material in, of bringing other opportunities in. Again, that's why I love a dream board. I've had parents do dream boards for their kids, and then we talk about how we can make things happen. And I think, again, if the primary motivation of the parent, even if it gets wrapped up, is to support the child, is to build the child, and every parent's going to say it, happy, healthy, safe, independent, then let's work with that. Let's find ways to put your values into practice. So that's how I would frame it with a parent. I would never say you're too close, or you're not seeing the potential, or you're letting your role as parent cloud your view of your child. I would view it as, it's a great thing that a parent wants to support the child. It is a great thing that you're an attentive parent. How can we add to that so you can be an even better supporter and a more effective parent? And then it's just a constant day by day or time by time providing of information, providing support to the parent, understanding where that parent's coming from. So much of their life has been subsumed more than they expected into being a parent of a child with disabilities. And it's letting the parent know that there are supports for him or her as well. Other questions? Then before we go, I want to do one more question I got from before, which was, how do we put a supported decision-making team's obligations in writing and have it be legally accepted? This is the advice I give for there are, I think, 17 states, Maryland just came online, that recognize and support supported decision-making agreements, that give them legal recognition. Ohio is not one of them. Okay, so I never recommend that people in a state that does not have a law recognizing supported decision-making to create a document called supported decision-making agreement. However, that doesn't mean you can't do supported decision-making legally. The way that I recommend, and we're going to discuss this in way more detail in the spring, is powers of attorney or advance directives. Parents can create supported decision-making relationships and give them legal status through a power of attorney or advance directive. Let me just give you one example, okay? The one example I'm going to give with regard to healthcare, for example, is that we can make a power of attorney that says, that's on your screen. God forbid something happens to me. I want Stephanie to make decisions for me, but here's how you're going to do it. When you have authority to make decisions for me, you're going to give primary consideration to my expressed wishes. We can be even more specific, like the one on your screen now, where I give you specific things that are important to me. I give you specific decisions that I never want you to make. I will never consent to shock therapy. I'll never consent to psychotropic drugs, and put in the power of attorney that before you make a decision, you got to consult with that list and consult with me. And you're going to work with me to make the decision I would have made, even if you don't agree with it. And if, God forbid, I'm not able to communicate what I want, you have to make the decision based upon what you know of me that I would have made if I could have, even if it is not something you would have done in the same situation. So we can create supported decision-making in powers of attorney. We can do it in powers of attorney around finances, where we can say, instead of you can't spend any money, I make all the financial decisions, one I did with a child in Maryland, you can spend X dollars a week without my okay. This is so easy to do now in the days of limited debit cards, where you're on a budget of X dollars a month. Here's your debit card. If you want to spend more than that, I have to okay it. So you're learning to make financial decisions and mistakes. You want to buy something stupid with the $100 a month, whatever you have, great, learn. But if you want to buy a car, mom has to sign off on that. But look at the bottom in the bold words. We can say how that decision will be made. You're going to have a conversation with me before you say yes or no, because I might be right. And then you should sign off. And I might be wrong. And if I'm wrong, it gives you a chance to support my development. You can talk to me about budgeting and what I have to do before I can buy that car. And just like that, I'm building skills. So supported decision-making can be built in to a legal document. I can say, for medical purposes, God forbid something happens to me, I want Steve to make the decisions for me. But if I'm okay, I still want Steve to come to the doctor with me. I'm authorizing Steve to come to the doctor with me, to be there, and I waive HIPAA for Steve to be there, so make sure that I understand the doctor and the doctor understands me. And just like that, it's an advanced directive, it's legally recognized, but it's got supported decision-making all about it. So those are some ways, and again, I know I flew through that. We'll discuss it more in the spring, but we can incorporate supported decision-making into legal documents. An IEP is a legal document. We can incorporate supported decision-making as part of the student's educational plan, just like we discussed today. Anything else?
As always, Jonathan, thank you very much for your time. We hit on a ton of topics today that I think probably, and most people here, just sparked new questions and new thoughts around the supported decision model. And I think that was, just talking to you yesterday and planning, that was kind of our intention around this. So I think we definitely met that objective. So I do appreciate your time today. I appreciate the participants and the questions you guys had and interactions that you had. It definitely makes the process more individualized to what your thoughts are and learning needs throughout our professional learning sessions. Keep in mind, Jonathan, like he said earlier, and I just want to reiterate it, this is not legal advice, although Jonathan is a lawyer. This is, the intention of this is best practice, techniques, tools, resource sharing, networking. But once again, it's not legal advice. So like Jonathan said, and like we always say at the SSTs, if it comes to some big decisions and legal ramifications, to consult your school district attorney, or if you are a parent, your personal attorney. There's also advocates, Disability Rights Ohio, the Ohio Coalition, things like that, for more of that, directed legal advice individual to your situation. Also, wanted to bring up the point that there was some kind of personal disclosures on this, hypothetical situations, things like that. If you are opposed to us posting this video on YouTube, we totally understand. We can also edit out certain things. There were some participants that were unable to attend today, so we wanted to make sure that we made this morning available to them, considering the content being so important and relevant to our work. But if there is somebody that is uncomfortable, now that we've kind of completed the conversation, with anything that they said or want their part edited out, we can certainly do that. Please just send me a direct email, and I will put my email in the chat box, and we will make sure that we respect your privacy and your wishes with that. If nobody has any other questions, again, April 5th, the sessions will be offered in sort of in a hybrid model, we want to say, but we are definitely certainly encouraging you to come to the ESC and meet Jonathan, meet our team. There will be some, built-in time to just kind of network, like I said earlier. And, you know, we would love to meet you all in person as well from the SST perspective, but we are certainly excited to host Jonathan in person and on site. That it's going to be April 5th. Again, start time is 9:30. Special education and vocational rehabilitation, healthcare and life planning, and bringing it all together to create coordinated support systems are going to be kind of our overarching topics, but there will be time, you know, built in for other discussion as well. So thank you, Jonathan, very much. Amazing as always, content as well as discussion. We appreciate your point of view and your, you know, the information you're able to offer, the resources and all of that. If anybody, like I said, has any questions or follow-up, please contact me directly. I'm trying to find my chat box to put my email in. If you have any questions, reach out. Otherwise, we will see you on April 5th.
Thank you all so much, everyone. I've put my email in the chat box as well. Please feel free to reach out. And thank you as always. It's just been my pleasure and honor. Have a great day.